All right, excellent. Is everyone ready? Awesome. It looks like, so we're going to hold a couple of bills, but I want to have them on for discussion. But let's start off with, we'll start off with Senate Bill 220 with Senator Heddleman. That's the criminal law, hate crimes, protected groups, and penalties. Jamie, you're up.
So Senate Bill 220 was on the voting list last week with an amendment. There's another amendment that's essentially the same as the one from last week, but has some technical fixes and also makes a couple of changes. The amendment in your packet should be number 608-374/1. Was it emailed to him or? Yes. Okay, so it should have been emailed to you. But essentially what the amendment does is it replaces the term in the bill, gender-related identity or expression, with the term gender identity, which is defined in the state government article. It strikes some provisions of the bill, and as amended, would provide that.
What are we on? So we're on Senate Bill 220.
So it would provide that in addition to any other penalties imposed for a conviction for a hate crime, the court may require a person who violates to complete an anti-bias education program. So it's an authorization for the court. And then at the end of the bill, it provides in the education article that on or before January 1st, 2023, the University System of Maryland shall manage the development of an anti-bias education program that provides anti-bias education relevant to the provisions of Title 10, Subtitle 3 of the Criminal Law article, which is the hate crimes subtitle. And that's the amendment.
I'd just like to say thank you to the chairman, thank you to council for working through these amendments, and we're very happy with them. So thank you.
I make a motion to let's adopt the amendments so that we can talk about the bill as amended. So, seconded. Is everyone okay? Okay, good. All right. Discussion on the bill as amended. Is everyone good?
No.
Okay. Okay, understood. I'm going to make a motion then for favorable.
Second.
We'll just roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
No.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter. Oh. Senator Huff.
Yes.
And yes. For me.
Sorry. Chairman Smith.
Yes, it's fine. Good. Okay, next we will go on to Senate Bill 7, Senator Simonaire.
So this bill expands and renames the Court Dog and Child Witness Program, an existing program. The program is renamed the Court Dog Therapy Program. The program is expanded to provide a facility or therapy dog to a veteran participating in a veteran treatment court proceeding. There are two amendments in your packets. Both of them are from Senator Simonaire, the sponsor of the bill. One of them renames the program again from the Court Dog Therapy Program to the Court Dog Program to avoid the misnomer between facility dog and therapy dog. And then the other amendment alters the definition of veteran by striking armed forces and replacing it with the term uniformed services.
Let's adopt the amendments first, and then so motion to adopt the amendments. Is that seconded? Fair? Fine. Everyone's good. Okay. Discussion? No. Senator Jackson.
Thank you, Mr. Chairman. At what point can I sign on to this bill? Okay. Yes, please. Thank you.
Okay, is everyone okay with that amendment? So we'll adopt that amendment, adding sponsors. So now the bill is before you as amended. So the motions for favorable with amendments. Seconded.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Huff.
Yes.
Chair Smith.
Yes. I'm trying to clean some of the easier ones out first. So next we'll go on to Senate Bill 236.
This bill requires specified counties to annually submit information to the Maryland Commission on Civil Rights regarding employment discrimination complaints. MCCR must include the data and recommendations, if any, for policy changes to address discriminatory trends noted in the data in its annual report. There is an amendment submitted by the sponsor at the hearing. She stated that there will be a clarifying amendment about who is responsible for collecting the information. So under this amendment, it alters information in the report. The amendment replaces whether the county Office of Civil Rights determines that a violation occurred to whether the appropriate agency determined that a violation occurred. And then if this is adopted, there's a technical correction to the amendment. Yeah, so if this amendment is adopted, I believe that there's a technical correction needed on page 2 of the bill, lines 20 and 21, where it states, on or before October 1 of each year, each county Office of Civil Rights shall report the following information. I think it might need to be each county of the Office of Civil Rights, comma, or the appropriate agency, comma, to correspond with the amendment or the change in the amendment.
Senator Heddleman, are you okay with those amendments? Okay. So the motion is to adopt the amendments. Everyone's good? Seconded, good. Okay. Discussion on the bill as amended? Sure. Actually, another amendment Senator Lee would like to be on, added as a sponsor. But then, is everyone okay adopting that amendment? Great. Senator Castley has a question.
Yeah, so I don't have any problem with doing reports. I just want to make sure we do the right thing. So I guess my question is really towards council. This would be capturing data just for people who file an employment discrimination case with the local office. That's what this is going to capture, right? I mean, it should just be a subset of employment discrimination cases that are filed, because you don't need to come through the local office, you don't need to come through the commission, you can,
So it would be reported by each county office of civil rights or the appropriate agency, and then that agency is then reporting this information to MCCR.
yeah, go ahead.
So this data is collected already. It's just getting them to further break it down. They provide it in somewhat aggregated way. It's just getting them to ask more questions about the kinds of employment discrimination cases that are filed already. So they do this report. It's just getting a little more granular.
So they just give like a generalized report about number of cases filed, but
They
don't break it
do,
down?
and they do have some specific, but this is getting them to more specific kinds of employment discrimination.
Okay, I mean, if it works, I just, that's fine. If that'll work, fine.
So, but this is further though, I mean, the agency that you file a complaint with and it works through this complaint process will report it to its, like from Montgomery County, it'll report it to its Commission on Civil Rights. That gets reported up, and then you're just making it more disaggregated, like, okay.
Exactly.
All right, so it's been amended. We've got two amendments that have both been adopted, so the bill is before you with amendments. Motions for favorable.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Castle.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. Senate Bill 253 is next. And we'll follow that with Senate Bill 293. Okay, Josh. So 253.
This bill requires a school bus to be routed with the intent that the number of pupils on the bus does not exceed the manufacturer's rated seating capacity for the bus. If an emergency or other temporary situation causes the number of pupils to exceed the seating capacity of the bus, the situation must be corrected within a reasonable period of time. The bill would take effect July 1, 2021.
So there's a number of bills this year that I feel like I should have run for county council, and this is in it. I mean, we're state senators, and we get into the specifics of how you do dog houses or how we do school buses. These are school board matters. These are county council matters. And this is also, as they say, you don't legislate common sense. So I just, yeah, you shouldn't build a school that doesn't have adequate bathrooms. You shouldn't, you know, I'm just to pass a bill to say you shouldn't put too many kids on the bus, then you can, yeah, duh. But if we start going down that road, we're going to be passing bills for everything. Move unfavorable on this.
Before that, I just want to, we've got a motion, it's been seconded, but before that, before we vote on it, just want to, why do we need to do this? Why does it have to come to us instead of their local jurisdiction doing this?
So my understanding is that there is something of an issue with school buses being overcrowded generally, and I think there may be some efforts underway to revise some of the COMAR regulations to maybe give school districts some flexibility, but I don't really know about that in particular. I believe this bill was introduced last year in the House, and as originally drafted, it was a little bit more prescriptive about what could or couldn't be done. But I think this was the version that it was amended to and was passed out of the floor unanimously, out of the House, that is.
Bill, then.
Figure out, I still just trying to figure out why the legislature has to do this. Does anyone know the answer to that question?
Yeah, I guess.
But why don't you go to their county council and do it?
I agree, it's the county council. I mean, if you read you shall route it with the intent. that's not really a law. It's you're routing with the intent. I mean, that's a county council kind of thing to say. Route it with the intent. It's, it's like, it reads like a zoning code thing, with the intent, routing with the intent. We're like, it makes us like Mike says, we're like county council manager people who are.
This is your school board. I mean, I've dealt with this before for constituents. I've had a lot, I mean, in rural areas, you get a lot of this, where they got to pick them up in certain areas, or they don't want their kids to walk, and they're arguing with the school that they should get a bus service. I mean, we constantly, I mean, at least I have gotten a handful of these since I've been in office. And you go to your school board and you try to work it out, but I don't come here and bring a bill against my school board. You work it out. The school board and the superintendent of your schools figures out bus routes. I mean,
I'm just thinking, so could the county executive do this? I'm not understanding. Senator Heddleman, you're up next. Hold on, wait. Just wait. Sorry about that. Yeah. Yeah.
It seems like it's absolutely in the right place, and it's consistent with the transportation article, which talks about school buses and safety. So it seems like this is already a topic of state law. So it just seems consistent, and it's a safety issue.
The state law is about school bus drivers. I mean, we can give the school bus driver a ticket. The school bus driver is responsible for the operations. We lay out the criteria for licensing school bus drivers. But this is a little bit different because this is, I mean, everybody uses, it's computer, they generate computer routes where they have the most efficient route, driving wise, and pick up all their kids. And all counties use that now. And it would be absolutely appropriate for a county council to say, I mean, they don't run the educational part of the schools, but they can certainly direct as a matter of policy about how your school, how your the intent that the school board's going to use when they lay out their busing routes. It's just that we're saying, if you look at the stuff above it, it says a school bus driver is responsible for and may not. And the person responsible for any people on the bus is the teacher on the bus. The teacher is not present, the driver. So you're established. And now this part gets into you routed with the intent that doesn't say you can't exceed. If we were going to say you can't put any kid on that bus who doesn't have a seat, then I'd say yes, that's appropriate for state law. We pass laws that say a bus can't be in service for more than X number of years as a matter of state law. But the intent about how we're going to do our computer programs about picking up kids, how do you?
Would it be possible to consult with the sponsor? Because I can't fathom that she didn't have this conversation with her local council people.
Well, yes, but I will say, I mean, if you look at the fiscal note on page 2, I mean, they do have some commentary from Anne Arundel. I'll just put it that way, but you can read that yourself. It's already in the record. I don't need to say it again. But look, the motion's been made. It's been seconded. So, so we're going to roll with it on the unfavorable first. See what happens. I think. If you look, the fiscal note is actually pretty instructive. But Senator Heddleman, would you have anything else? Or, I mean, anything else? No one else?
I mean, it's just, yeah. I mean, if you look, it's a local fight. I mean, it mentions Anne Arundel in here. I mean, look. I don't have a dog in the fight. It says Frederick County, it's fine. But it seems like a local county issue, and I just think I want to try to personally this is, I've always tried to veer us away from becoming the county council. We get this a lot, these county like little issues or fights or things that would try to force us in a role of telling county people and school superintendents and school boards how to do their job.
I don't care.
Rolling on the unfavorable.
We're rolling on unfavorable, see what happens.
Vice Chair Wildstraker,
No.
Senator Lee,
No. Sorry. No.
Senator Castley,
Yes.
Senator Heddleman,
No.
Senator West,
Yes.
Senator Sidnor,
No.
Senator Jackson,
Yes.
Senator Bailey,
Yes.
Senator Carter,
Yes.
Senator Huff,
Yes.
Shit, Liz.
Chairman Smith.
What is it at? It's dead? Yep. All right. So then I'll vote no on the unfavorable then. If you're feeling bad about your vote, look at the fiscal note. Look at the fiscal note, yeah, I mean,
To be honest, like, I know it gets so hard in here to kill bills. It shouldn't be, but that's an easy one. I mean, we got a tough, you're making a state law, we're state senate. There's gotta be a barrier here.
all right.
It is.
Senate Bill 293.
This bill prohibits an individual from causing the serious physical injury or death of a vulnerable individual as a result of the individual operating a motor vehicle in violation of any rule of the road specified in the vehicle law. A violator is guilty of a misdemeanor and subject to a maximum fine of $2,000. An individual charged with a violation must appear in court and may not prepay the fine. The court may, in addition to imposing a fine, order the violator to participate in a motor vehicle safety course and perform up to 150 hours of community service. The MVA must suspend the license of an individual convicted of a violation for at least 7 days and up to 6 months.
Discussion? Senator Sidnor.
There was an amendment requested I put in just for the removal of the farm tractor or farm equipment, but I don't know if it's come in or was received by this committee at the time. Okay.
I haven't received the amendment.
So do you want to, I mean, sponsor the bill, what do you want to do? What do you?
A lot of farm tractors, but we do have districts represented here that do, and I imagine they want to keep it in the bill. So I'll defer to the gentleman from Southern Maryland. But
Is it a big deal, Charles? I mean, because part of my district is Prince George, and then I'm Charles and Calvert.
Don't worry about it.
Appreciate it.
Any other further discussion on the bill? No?
motion favorable, Mr. Chairman.
Yep, I'll second that, but Senator West.
Thank you, Mr. Chair. I just have a question that's bothered me all along. So in the definition of vulnerable individual, it's given 3 subparts that define it. In the 3rd subpart, it says an individual who is lawfully operating or riding, et cetera. But in the 2nd part, it just says an individual who is riding or leading an animal on a highway. Shouldn't we add the adjective lawfully to part 2, and also, while we're at it, add it to part 1? So if a pedestrian is on a sidewalk, or, well, I would assume sidewalk, I don't have as much problem with number 1, but you know, if somebody's out in the middle of the street at night with no reflective gear and gets hit, I don't have as much sympathy for that person because they're not where they ought to lawfully be.
Do you need to withdraw your motion first so we can amend it?
Yes, I withdraw for
Okay, got it.
purposes of an amendment. I think we can do that amendment orally, if it's okay with Josh.
Can you,
Yeah, that, I think it would simply be, you know, in page 2, line 12, it would simply say an individual who is, and then you could simply insert the word lawfully riding or leading an animal.
That's my amendment, that one word. Yeah, I'm not as strong on that, but wouldn't have a problem putting lawfully in line 7 as well. So long as they're lawfully there, they should be protected. But if they're doing something which is not lawful, like being out in the middle of the street, that's something else again.
That's fine. That makes sense.
So it would be in both A1 and A2 then? Okay.
all right, yeah, can we move for the adoption of that amendment? Everyone cool? All right. Do you want a motion for?
Motion for favorable.
It's been seconded. Any further discussion? No? We'll roll it.
One quick question, and just because I have the veterans home, the largest veterans home in Maryland right up the street for me, and now that we have these motorized wheelchairs, but I'm going to tell you, I didn't even know they could legally drive those on the highway. What's that?
No, I think it's if they're going across a crosswalk. You can't drive those things on the highway.
Those things aren't street legal, are they?
No, this is saying you hit them when they're on like the.
If they're in a designated crosswalk?
Yeah.
Okay.
Do you have your Amish? Are they in this though?
The
Can we
Amish
get- can
are
we get,
okay, they're covered in here.
Can we get Josh in there?
So, I'm just, Senator Bailey, I assume that's why the term lawfully was put in there, because, you know, if they're operating on a highway without registration, that would be unlawful.
Thank you very much for that. I was just like,
I have a question. What is the current law? So because I'm looking at page 3, the lines 13 through 15. So it says that they shall suspend the driver's license if they violate B above. And what is the current penalty?
So, I mean, in terms of a suspension, it would depend on exactly what violation they ended up charged with. So, you know, if you accumulate, I think, 8 points over 2 years, that would be a suspension. So if you were charged with a violation which carried that many points, you would be suspended automatically.
Okay, so how is this changing this? So
Well,
it's
this would mean that
no
you would have a
discretion.
suspension, or you could have a suspension no matter, you know, even if you hadn't hit the amount of points, you know,
Right.
that would normally merit one.
Okay, yeah, could we change it to May? If it's okay with the sponsor?
We've been sensitive about mandatory sentencing here, and so yeah, that's fine with me. If the judge deems it in the interest of justice, yeah, absolutely.
That is on page 3 on line 13. That's okay.
I'm just having trouble because you see the administration. We don't usually give them discretion. We give judges discretion, but the administration, if you're found guilty, they just impose. I mean, where's?
I lost you, Senator Castley.
What's that?
I said I lost you.
So we're on page 3, line 13. It says administration shall suspend. And we're going to change that to a may. I'll defer to council. It just seems to me that we don't usually grant the motor vehicle administration discretion.
That's a good point. I thought we were talking about
We give
judges.
judges discretion, courts, even ALJ's discretion, but I mean, I'm not sure how they're supposed to distinguish between me and you.
Right. Yeah, that's a question for council. I don't know how that works, the interplay between what a judge does and what the MVA does in response.
I mean,
They-
if you're going for leniency, you go under line 8. You get to the court and you get them to bend it for you. But if they don't bend it for you, then the administration typically just has to impose.
So I think there are scenarios where the administration could exercise discretion. I think one key issue here would be, how would they know to even make that decision? So if you wanted to leave it as a may and give the administration some discretion, you could say something like the court shall send a notice of the conviction to the administration who would then exercise that discretion. Or the judge could simply be given that discretion.
Yeah, I don't know how it works in practice. Do judges have the ability under other parts of the transportation article to suspend a driver's license? Or does it always read? It always goes to the MVA?
Suspension.
Not directly. I mean, there are certain convictions that when the MVA receives notice of them, they are required to suspend. But the judge, I don't think there are any provisions we have where the judge makes that decision themselves.
Got it, okay. And are there other portions of the code where the administration has discretion, as you've described?
Well, like when it comes to drunk driving, if you have then you go for the hearing before the hearing examiner, and they have discretion there because you put a hearing on before them. But I don't know that something like this would end up. I mean, this is sort of whether you get the points or something for a speeding ticket.
Well,
I mean, we can pass it in principle, put the may on there, and we can check with MVA and see what their counsel and see what you want to do. I mean, I'm fine either way. I just want it to be technically correct. So if we want to say we'll pass it in principle, and you guys can check with the motor vehicle people and see if the may works. If it doesn't work, we go back to shall. I have no problem with the may as long as it's appropriate.
What do you want to do? How do you want to do that? I mean,
Can we just pass it now as a committee and say it's a may, but if the MVA tells us you can't do that, then it automatically reverts to a shall? And just bring
I
it
think
to-
we can.
I don't know if we
do
can
that.
automate it like that. I mean, we could take it off the floor and re-refer it, but that's
I don't
a
wanna
little
do that.
dramatic for
Yeah.
a bill like this.
If
I
you
mean,
want
the only other option is I would say you
Let the House
could
deal with the problem. I don't care.
You could hold it for. That's the only other option I could say. I don't think you should. I mean, unless you want to amend it on the floor, on second reader when you first read it.
Like
Could do that.
Like a committee amendment, you're saying?
Yeah.
Why don't we do that? Why don't we, if it's okay with you, Mr. Chairman, why don't we change it to may here? We will check with the MVA to understand the mechanism here and then amend it on the floor. Or, I mean, it looks like you want to do a shall here and then,
If we know, we shouldn't release a committee product out unless we're ready to.
okay, let's hold
release
it.
out.
Let's hold it.
Okay.
That's fine.
Yes.
If we leave it in as a may, the administration can propose a rule in Comar which would set forth the circumstances in which they would exercise discretion as opposed to not. I don't know why we, as legislatively,
All right.
have to tell them how to.
Just hold it
That's fine.
while we get the answer to that. So Senator Hedelman and Senator Walsh-Reagan, could you all work on that?
Sure.
Okay. We're holding it, yeah.
With the already adopted amendment. So in other words.
Yes, so we're holding it with the amendment that's already been adopted. So, got it, Josh? Okay. Next is Senate Bill 315. It's also Josh.
This bill prohibits stopping, standing, or parking a vehicle in a designated plug-in electric drive vehicle park charging space unless that vehicle is a plug-in electric drive vehicle. The bill establishes requirements for signage and pavement markings for such designated vehicle charging spaces. The bill also establishes that a person who violates the provisions is subject to a civil penalty of $50. The bill authorizes a parking facility that is privately owned or owned by a local government to have a vehicle towed or removed if it's in violation of the bill. Local governments can also ticket vehicles in violation of the bill. Any local law authorizing towing or removal from a facility owned by a local government must meet or exceed the standards set forth in state towing laws. So you should have one amendment in your packet from the vice chair. This would remove the ability for private and publicly owned lots to tow for a violation of the act. And I've been told by the sponsor that he has requested another amendment. It's a very simple amendment. It would simply remove subsection G at the very end of the bill, which requires the Department of Transportation to adopt regulations. I believe the thought is that the bill is already prescriptive enough that all the rules are already set forth in the bill.
That we should wait for, or that you could do in concept here?
My understanding is he's already submitted it to the amendment office and it's being drafted. It would simply, all it does is delete that last subsection G. So
do you, as committee counsel, need to wait for that amendment for us, or can we just do it here now?
I think you can do it here now, and I could even draft it myself if it hasn't been done already by the amendment office.
Can I suggest another amendment real quick?
Sure. Senator Castells?
I mean, I know from what he said that the sponsor's goal was to keep people from not protesting in these spaces, which that's fine. They shouldn't do that. But I think you also have to look beyond this and recognize that those people aside, you want to actually use these spaces for people who are parking. It's not intended to be like a, space reserved for the president of the company. You're supposed to be so you're actually charging. Seems to me to really make the bill useful. It ought to say that you can't park in that space unless you're charging. I mean, obviously you can't, but it ought to be at least plugged into the charging mechanism. And this just shouldn't be like a handicap parking. Anybody with this license plate can park here. And actually reserve these for people who are, you got to go through the extra step. You don't park here, get out, open it up, charge, put it in, and.
This little policy, like,
Well, I'm afraid that's how it comes across.
Your car, you already get the HOV lanes you get to use, and then you get your VIP park in right in the front, and you get it treated like a handicap spot if anyone else parks there.
And I think moving forward, you're going to have folks who are just going to use it in that fashion, and you got other people who are trying to park their electric vehicle in there to charge it, and people are just pulling in there and parking. They can't.
I can offer that as a committee amendment. If not, if you want to, I don't know if you want to go through the rigmarole of working it up. Can you do that in concept now? Can you do that?
Yeah,
Is
I think
that
you
more
would,
complicated?
maybe on page, let me see, what page is this? On page 2 in maybe line 24, where it says unless the vehicle is a plug-in electric drive vehicle, you would insert something to the effect, which is in the process of being charged or is plugged into the charging equipment.
It's charging.
I can't tell you that your vehicle's charged, but it's plugged in, right?
So it might be adding, it would say, unless the vehicle is a plug-in electric vehicle which is plugged into the charging equipment.
Right. Yeah.
This is a little far-fetched, but I don't like actively charging or because I feel like there'll be other mechanisms of charging in the future that aren't plug-in. Do you know what I mean? Like, it'd be like a proximity thing. You could be over. Like, do you know what I'm saying? I don't know.
Maybe plugged in or actively utilizing.
Once Elon Musk's developed that technology, we can come back and amend the bill, I guess. I don't know. But charging?
I mean, my problem with the charging is
how do you know?
Now it's charged up and you're still sitting there, so I'm going to ticket you because you've been there for an hour.
You don't know.
I know. I don't
But
know.
I
That's
mean,
why
if it's plugged in, you assume it's charging. Is that fair?
Yeah, but you could have a full charge and still plug in.
But how, you're not going to get it.
But at least you got to get out the car and do it.
If you think that technology's coming, you say plug in or actively charging.
I mean, that's what I mean, I don't know if that's a technical term. I have no idea how you. You have like proximity charges. You don't have to be connected to anything.
So what's wrong with saying plugged in or actively charging, to leave it open for the future?
I guess that works. Senator Bailey has a question.
My question is, and I don't see the amendment that says about removing private area, but my question is, the way this is worded, I just want to know who the police are that are going to show up and write a ticket on somebody's private property for this park there. I mean, you know, the state police aren't going to do it. The county police aren't going to do it. We're making a state law on somebody's private property. On a private lot? On a, if it's a state property, then you're clearly going to write a ticket on that, right? But if it's a county, it should, this on a private lot, in my opinion, should be done by the local jurisdiction. They should do this locally in there, because this would be just like an ordinance.
He's saying your county police are the ones that are going to hit you. He's saying the county police are going to hit you, the ones at the Walmart, when you do this, right? So you would have your Frederick County or Montgomery County government doing it. So that's a good question, because what are we actually enabling? Because can't the locals do that part already?
Like that. And we have, like all your parking for handicap stuff, those are issued by town police, county police.
Yeah.
But it's a state-enabled statute.
Yeah, but I thought some of the locals, I thought Montgomery County was already doing this. Am I wrong?
I guess they can pass the local ordinance if they want to.
So, Mr. Chairman, I think, you know, in Prince George's County, I think Montgomery County as well, I think we have the Revenue Authority, which has the Parking Authority folks that go around pretty much that does that, instead of police doing it. So is this what we're trying to get to here? But I'm not sure every jurisdiction has that. You know, a parking authority. It's like, you know, the meter readers or the parking authority folks. And I understand the concept. And how long, I don't have one of these cards, how long does it take to charge these vehicles? So if a person is charging a vehicle and they go into the mall and they, you know, they run over time, you know, are they getting ticketed because they got caught up or swept up in shopping or a movie or something? We're probably overthinking this, right? Until I get one of those cars.
Well, I think it depends on the kind of car, and like, I think maybe if it's a hybrid or if it's a fully electric. I have here, you know, as little as 30 minutes or more than 12 hours, so I know that that's not particularly helpful, but.
Clear, but the Revenue Authority, Vice, you know, local police, local county police, or, you know, the county revenue authority, who's going to be enforcing that?
I'm not.
Like, if I go to Montgomery Mall.
I'm not sure about that, honestly. I have to look into that.
And they do them all as well.
Nothing's easy here. Yeah. It's like, we'll talk offline about this, Josh, but we'll work it out.
Like on the side of the easy bills.
Yeah. All right, Senator Heddleman, Senate Bill 75.
This bill generally requires a person age 85 or older to appear in person at an office of the MVA in order to renew a driver's license. You should have one amendment from Senator Castley, which would add to the bill a modification of an existing requirement that when an individual's driver's license is about to expire within 60 days, the MVA has to send them a notice of the expiration. And what the amendment would do would simply add to that existing requirement that if the licensee is going to be at least 85 years of age at the time of the expiration, that notice would have to also include information on how that individual can apply for a non-driver's license ID card from the MVA.
This is the one that you had an amendment idea for, didn't you?
Is this that, okay, I thought you had another
Right through
idea.
your amendment?
What's that?
I thought you had another one. There was going to say that the ID was still, it was,
Well,
oh, got it, here it is.
Yeah, I mean, my original proposal, this is what we ended up with. My original proposal was that that they would, you know, if I go in for this in-person thing, it would automatically convert to I don't have to do a reapplication. If I apply, if I'm 85, I go in for the driver's test, I'm walking out with either an ID or a driver's license, but I'm not going to walk out with nothing, so I don't have to come back. So, I mean, this, I'm not sure where this language was sort of was proposed. Wasn't going to make a huge, I assume that my idea wasn't floating with MVA or something, but I was trying to minimize the 85-year-old from, you went all the way in there and you walked out with nothing, and now you don't even have your license. You got to somehow get a bummer ride back there to get an ID, and that they would just have to automatically convert it on the spot to an ID.
Yeah, that's what I was talking about. Were you talking, it was going to convert at least to a state ID?
Yeah, so you walk out with something.
I think the only complication with that is that the non-driver's license ID has some documentary requirements that you're required to present, so.
So I'm just, I mean, how can a state ID non-driver's
Isn't
license
that
have more
lesser?
requirements than a?
No, I don't think it would be more. I would have to check in with MBA to see if they could simply say, what you submitted for the driver's license, we'll do it for the other ID card as well. Or
I mean, that's
whether
the-
you would have to resubmit certain documents.
Can we do that real quick? Can we just check with the MVA and hold it and do that? Because I think that the MVA ought to be able to just automatically do that. Here, sorry, Mrs. Jones, you failed the eye test, but here's your ID.
I think that's right.
I mean, she's going to have an ID. She's been riding on her license for 50 years, and now she suddenly doesn't have that. She's got to have something. You might as well automatically convert it right then and.
Senator Heddleman.
I don't have a copy. I don't know where the amendment is. It wasn't in the initial group, was it?
So I sent out probably 5 or 6 emails. We got a lot of late amendments, but everything was sent.
I'm just looking through. It wasn't in the initial big packet, right? It was in a later one?
I think this one was in the initial big packet, but again, we got a lot of late amendments, so I'm not 100% sure. Josh, do you remember, did you give me this morning?
Yes, I did.
Okay.
So it's just, for reference, it's amendment number 518574/1.
Well, Senator Castle, let's hold it for that for your revised amendment, because I think it's a really good idea. You should definitely have an ID when you come out. All right. Well, then we get on to a little bit more meat here. Senate Bill 98.
Okay. This bill prohibits a local board of education public pre-K program, non-public pre-K program that receives state funds, public primary or secondary school, or non-public primary or secondary school that receives state funds from discriminating against any person, refusing enrollment of, expelling, withholding privileges from, or otherwise discriminating against any student or prospective student because of the individual's race, ethnicity, color, religion, sex, age, national origin, marital status, sexual orientation, gender identity, or disability. Further, retaliatory action against a student or parent or guardian of a student who files a complaint alleging specified discrimination is prohibited. The bill establishes a complaint, mediation, and appeal process for violations. All or part of specified funding may be withheld from a board, program, or school that violates the non-discrimination requirements. And there are amendments in your packet. Some of the amendments were in like the initial email. Some of the amendments are in the later emails. Yeah, so one of the amendments is from Senator Smith. It's amendment ending in 79. This amendment alters the bill's prohibition on discriminating against any person due to the person's protected class. So under this amendment, the prohibition is subject to the provisions on discrimination in employment in Title 20, Subtitle 6 of the state government article. And then
So Senator Council, that went to your concern about teachers and not students.
Different, they're going to the same
Same
purpose.
point. Yeah, I mean, this amendment's almost like just a restatement of the law. I mean, of the current law. It just puts it into this section, right? I mean, it's basically lifted. Same. I mean,
Well, what am I missing? And why is the Catholic Conference and these other groups? There's a Orthodox Jewish school in here that all testimony against it. I mean, if we just restate that they already operate under the current law.
No, it's not. It changed a bit.
They're arguing different things in there that they're saying it's not the same. Because I was under that impression too, but now I'm reading the testimony.
I'm looking at it right now. Like the Catholic Conference.
I'm reading one right now from, I read that one, and then it's I'm going to look up. Agda, Israel of Maryland.
Yeah.
Senator seeks to dissolve and undo the identity of the schools, making any available state funding hinged upon the dismantling of admission, retention, and employment policies that have existed since time immemorial.
that was a reference to employment.
Yeah, I'm not.
So, for the two amendments that were submitted, they were both submitted this morning. Sorry, I was talking about a different bill, so they should be in the first.
Cape. Yeah, I'm just want to read it right now.
No, Mike, the real difference is if you look on, like, for example, if you look at, you have my amendment in front of you?
Yes.
Okay, the key part on my amendment is on page 3, line 16, says discriminate against any person. This changes it to student. Makes the same change on page 6, line 1, changes it from person to student. The idea being that in the budget language, it was clear that the budget restrictions applied only to discrimination against students, not to teachers. And that an Orthodox school, a Christian school could hire whoever the heck they want to be their teachers, and they
That's
could
what that's what I'm trying to figure out, because every year we get this fight on the budget language has in there, you can't discriminate against students. That always passes, and then there's somebody always offers one for the teachers, which has not
and
passed
that
yet.
one fails. And when I asked
And then his
Corey-
bill is usually the teachers, but then this year they came in and said it's not.
So when we asked, Corey puts the bill in, I asked him, was your intention to change the budget, the language we usually do, and he said it was not his intention. And then I pointed out that, well, you've gone from students to persons, and at that point, I think it was sort of, well, we need to talk about it.
I would need to review the employment. What was that, Title 26?
wouldn't a teacher be under that anyway, by definition?
They're a person to me.
Look, I don't think we're saying that. I'm trying to figure out what the difference in your amendment is, what the effective difference of your amendment and my amendment are.
Oh.
You know what I mean? I mean, I don't have a problem with you saying that.
Yours doesn't take out the person language. Yours leaves the person in, not just student. And the problem with that is the intent has always been discrimination on students. But if it's person, then that could include the teachers and staff. The bill would be interpreted
Meaning that you could not discriminate, but differentiate for teachers.
right. The budget language has always allowed schools to employ only, only
got
Jewish
it.
teachers, only Muslim teachers.
It always passes because it's part of the budget.
It always passes because we don't go for the teachers piece or the staff piece. We always just go for the student piece. Teachers and staff are subject to the other requirements in the law that require, they are subject to certain other anti-discrimination pieces in the law, but it does, the rest of the law allows flexibility for a religious school. And this would, the support, the private school folks who support this amendment are saying, the way this reads is, you're changing the rest of the law on discrimination. If that's not your intent, it should be clear, and that's all this is intended to do, to make it clear that this bill relates to the students, it doesn't change anything with regard to the students, and it's only the faculty.
It seems like, they put boast in every year, then they put this language in there every year. I just don't understand why. He's senators from budget and tax. He's brought in a bill that's done otherwise, but I don't understand why a bill to reinstate what they already do in budget tax. If he doesn't like the language, why don't they just amend it on the budget?
You got to do it every year instead of having it enshrined in code. I mean,
I would agree with that. Why not just leave this in the budget? It's always worked there, and suddenly we're deciding we want to bring it into the code, which is why the schools are concerned that this has been working every year, and suddenly you're changing the game here. What's up? And then they read the bill, and it says, it looks pretty clear to them that we're not just doing anti-discrimination on the basis of students, but staff also. And that's what my amendment is intended to collect. And it also just clarifies on page 4 the additional clarifying language on what rights are there, on what it doesn't restrict. It prevent them from entering into an agreement or take any action that inhibits the free exercise of religion's rights of the non-public pre-kindergarten program or non-public school as a condition precedent to applying for receiving state funds.
yeah, that's it.
Yes, that's in the packet.
Senator Heddleman, did you have something to say? I got it.
I've got another concern. I don't know whether the language is complicated. I don't know if it covers it or not, but I raised it at the hearing, and it's the question of many private schools cannot deal with disabilities. I talk about autism. I could also talk about dyslexia. Some schools are quite clear about it. They cannot deal with dyslexia, and they will not take dyslexic children. So where in this bill are such schools permitted to discriminate in accepting kids to attend the school who are dyslexic?
That's in the Catholic Conference, their opposition, what you're saying. I just read it in the Catholic Conference testimony.
Well, I came up with it independently, but it's still a good question.
I do the cheat sheet method, so they
page
said
4,
the same
lines 8
thing.
through 11.
So
And I know that because the school I attended, one of my classmates, he had kids, and I said, "Are they going to the school?" And he said, "No, one of the boy is dyslexic." And the school was quite explicit, they cannot educate dyslexic kids. So the kid had to go to a school specializing in educating dyslexic children.
On the list of things it does not apply to.
yeah, it's additionally creating disability as a protected class against discrimination does not account for the fact that not all schools, whether public or non-public, can accommodate each student. As to do so would be the student's detriment if the student was not equipped to accommodate them.
So
The school was not equipped to accommodate them.
So then, Chris, how would you interpret page 3, the bottom? You start at 29, line 29, and you go, this subtitle does not apply to, right? And then you switch over lines, page 4. Line 8 through 11.
Yeah, well, the problem with that is it says, with respect to discrimination on the basis of disability, a non-public public school that provides a student with a reasonable accommodation under federal law. I don't know what that means. Does that mean if a student with dyslexia applies to a private school that can't educate the child, that the school has to pay for the child to go to a different school?
No, so I know this. So I remember I asked this during the hearing because in
Yeah.
federal law, like if you, as long as you've done your best effort, if you don't have the ability to make that reasonable accommodation, you're not on the hook. You're off the hook. The agency's off the hook.
Well,
So I asked for we should.
This says provides. It doesn't say attempts to provide or considers providing. It says provides the student with a reasonable accommodation. We're on page 4.
Page 8 through 11.
Yeah.
We could clarify that.
You mean, what's a reasonable accommodation? Yeah.
And again, in federal law, there's definition, but I don't know if the state. I don't know. I'm familiar with this in the state.
And then there's a section right down below that seems to sort of contradict it. It's 26-702B in lines 15 to 20 that says this subtitle does not require a non-public school to enroll a student who does not meet the usual and regular qualifications and standards of the program, provided that the denial is not based on discrimination on the grounds of disability. So that language seems to suggest that a school must enroll someone who has a disability, even though that person doesn't meet the usual qualifications.
They have a definition of. Yeah. So reasonable accommodation. A reasonable accommodation is any modification or adjustment to a job, work environment, or program that will enable a qualified employee, applicant, or recipient with a disability to perform essential job functions, participate in the application process, or benefits of the service and/or program. That's so undue hardship. This is the word. That's what I was looking for. So.
Reasonable accommodation, is that the language that's always used in all the public school litigation about whether when a parent comes after the school, whether the school has provided reasonable accommodation for their disabled child? And that's a pretty steep bar right now. The public school has to provide a whole heck of a lot of accommodation.
All right, so here's what we'll do. We'll follow up on the clear definition of reasonable accommodation, and then the undue hardship for the school that they would have to prove for not providing that reasonable accommodation. We'll have clear guidance on that when we come back. So I'll have the answer for you, Senator West. And then student, I know he said that, but then is that sending the wrong, like, sorry, go ahead.
So under Senator Smith's amendment, it makes it subject to the Title 20, Subtitle 6 of the state government, which deals with employment discrimination, but it still leaves in against the any person. So they would still need to, Title 20, Subtitle 6 would control for like employment, but because of the any person, if it was someone other than a student that was being discriminated against who wasn't an employee, this would still be prohibited. But if you strike the any person and you just sub in student, then it would specifically limit this discrimination act to a specific student, not a more general any person.
Yeah, so I mean, the maker said this was about the students, not the teachers. So I don't know why, I'd like to move the amendment, my amendment, and just remove that as an issue. Yours is saying that what's already the law. They're already subject to all those requirements of the federal and state law. They have no exceptions to those, right?
These are the exceptions right here. So I guess if that's there, I mean, it's like a double overstatement, I guess. I mean, put teacher.
Discriminate against any student or parent because of.
Yeah, I mean,
Right, so the
it's already those.
this part of the state law gives you an exception, but then it looks like this proposal would be totally contrary. It would pit them against each other, because you're establishing a new standard here unless you make it clear that that's not the teachers. The teachers are covered by that.
Yeah.
We want to leave that there.
Yes.
Don't put the teachers in here. They're already covered in there. Nobody wants to change that standard. This is only about students, so let's make it clear that it's only about students, and adopt my amendment. We're not changing anything on teachers. We're just saying that you can't, if you're getting this state aid, this additional state aid, we're also applying special standards just to students, and you can't discriminate on students, because that doesn't cover students. That's only about teachers. Let that go. Leave that for the teachers. This is students.
Senator Westbrook, then
So my mind is swimming a little bit on this, and I just want to be clear. I understand the desire to limit this to students. I think that was the intent of the sponsor, and obviously we have a Supreme Court case. When we specify student, I just need to understand what is the safety valve so that we're not accidentally implying that schools can discriminate based on race or gender or anything not protected by the recent Supreme Court decision. And that's the safety net I need in order to go along with the direction of it.
I mean, these religious schools, all with staffing, they can discriminate on gender. If they have nuns teaching, they don't have to allow males to teach.
Yeah, I'm sorry. I mean, my point is so that we don't accidentally say that they can do something that they are currently not allowed to do, except for the Supreme Court case.
I think we need to get this language right, and whatever amendments we do, I'd like to check, because I want to know what we're doing, what we're getting into, because this is a big floor fight every year. So
No, I agree.
I just want to have an understanding, because if everything we do is copacetic and all these schools say, hey, look, this is fine, I can go back, we can say at our caucus, this is fine, and it's not a big deal on the floor. But
No,
I just want to have an understanding what we're doing.
Are you? I'm going to pull, so for Title 20, Subtitle 6, and then the exceptions, I think it's important. We pull that, send that to the members, just so they understand, like, what the exceptions are. That I'm pretty sure that teachers are already covered under this, because it says, a school, college, university, or other educational institution for hiring and employing employees of a particular religion if the institution is wholly or substantially owned, supported, controlled, or managed by a particular religion or a particular religious corporation, association, or society. The curriculum of the institution is directed toward the propagation of a particular religion, or so on and so forth. So we'll pull that and make sure everyone has it for the next voting session. And then we'll make sure we have the reasonable accommodation and the undue burden answer. What else? Oh, yeah. Senator Hedelman has a question, and then we'll...
Again, if you could also give a clear explanation of the difference between your amendments, that would be really helpful.
Yeah.
Thanks.
We'll do a little memo. Yes, let's finish up the rest of Senator Cassidy's amendment, and then we're going to hold this for that work, but we'll move on after that.
we already went over part of Senator Cassidy's amendment, which switched the any person to discriminating against any student. Okay, school to enter into any agreement or take any action that inhibits free exercise of religious rights of the non-public pre-K or school as a condition precedent for applying for or receiving state funds, and that appears on page 4. And it also strikes the requirement that a non-public pre-K program or school that receives state funds develop and maintain a written anti-discrimination policy, and that appears on page 8.
So he strikes that?
So yeah, it strikes, so the non-public schools are still required to do it, but that's in a different section. It just strikes the requirement that applies to the non-public schools and programs.
Why would you? Subtitle under section 26-703. Where is that?
That's the whole anti-discrimination policy.
So,
So
if
yeah,
they take
so-
state money, no, that's, we can't. Okay. Yes, Senator Jackson.
So I think, I was looking at the testimony from the hearing and the submitted testimony. It seems that they are pretty much in line. And I think what Senator Cassidy is saying is probably spot on, but, you know, I know from the budget side, we typically deal with these, and I know that the last couple of years, I think they were brought into the budget committee as well to talk about the discriminatory practices. But if you look at the unfavorable testimonies, you're all lined up to say the same thing. So I think I'm in line with where Senator Cassidy is, but I'm also wondering, you know, because this typically ends up in the budget committee. And is it specific to us because they're trying to add the employees? Although I couldn't tell by testimony the other day.
It's just for us because it's. I mean, he's trying to enshrine this into the statute, so we don't have to have this, you know, and this, which is, you know, the discussion we were having earlier, which is we've had this kind of discussion every year.
Right.
And the reason why it's not as big of a deal is because it's coupled with the rest of the budget, so people are like, all right, you know.
Right. Right.
And then, you know, you guys do the good work in the budget committee already. It comes to the floor, everyone just rolls with it.
And so they're trying to pull it out of the budget piece and enshrine it. That's a challenge, huh?
We agree on that every year. We agree on, I mean, people sit down from the various conferences, the
Right.
various religions, and they've agreed upon the standard language. And, you know, Senator McCrae's originally said his intent was to take that language and put it in statute. But then the conferences came back and said, wait, you didn't just take that budget language and put it in statute. You made some changes, and that's what they were upset about, was those changes. Specifically, their big one was the person part, which, to me as an attorney, it would apply. And now you'd have this applying to teachers and the other statute applying to teachers, and you're pitting them against each other. And there's no reason to do that because teachers are already covered in the other statute. It already sets a clear standard that nobody's upset about on discrimination in the case of teachers. This should just apply to students. And the whole objective on this one is you're getting state aid for your students. You don't get state aid for your teachers. You get state aid for your students. And so if you're taking our money, you have to abide by these provisions. And so I'm not sure why we need to put, you know, the teachers in here as well.
I got it.
Because they're already covered.
I think we're close on that. And if we can just make sure that's the case and then we can actually articulate that, that's the clean thing.
And honestly, I'm not sure. I'm looking at the amendment, because they gave me the amendment on the last page that says they don't have to develop a policy. I'm not sure why that's in there.
Yeah, I was like, I don't want to do that. But, so can we just, are you withdrawing that piece of the amendment then?
Well, we're not going to, we're holding everything, right?
Yeah.
Let me just,
Okay.
in my mind, I'm like, probably that piece, but let me, before I
Got
say
it.
that.
All right, good, because we were going to fight on that one. All right, cool.
Yeah, I'm like, why would you have a policy on, if you agree to this part, have a policy
You're fine.
on it?
Yeah.
Okay.
Got it.
Huh?
It's probably something they do anyway. Yeah.
Why?
Okay. All right. So we're gonna hold it, and we'll have the answers. We'll figure it out. I
I'll
mean,
forward after this. Yeah.
all right. Now we are on then to Senate. That was 8, right? So we're on 9 now. I sent over. So Senate. Let's do Senate Bill 14, which is Senator Kelly. It had a really good hearing, and I thought we made some good progress on it. So I put it up here for discussion at the very least. And I think I sent it over to Cashley just to see what you thought. Again, just if you had any additional amendments or anything. I know it's a quick turn, but I wanted to put it before the committee early on. So actually, can we first, Josh, let's discuss the amendments that were discussed during the hearing.
So yeah, these amendments from the sponsor, a lot of it is clarifying certain language. It would also clarify that a petition for compensation must be filed with the Office of Administrative Hearings and at what the required caption for that petition would be. It also narrows the eligibility for the modification of compensation already awarded by the Board of Public Works. So under the bill as drafted, it's anyone, I believe, between January 1st, 1984 and July 1st, 2021. So the amendments would take that down to July 1st, 2005. So from the sponsors say, and there isn't an updated fiscal note, but the sponsors say that would cut the amount of exonerees who are eligible for that modification from 15 down to 5. So it should have a significant impact on the initial fiscal note in fiscal 2022. The amendments would also allow an administrative law judge to recommend that compensation be awarded to an exoneree on an expedited payment schedule, as opposed to the normally prescribed, one payment and then additional payments over 6 years schedule.
On this one, because I know I was sort of the bugaboo with this one last year, and so I give Senator Kelly and the other folks involved in this, I guess Delegate DeMay too, a lot of credit for moving forward with it. My concern last year was that you can be found, you can, a court can reverse your case and they can elect not to try it, not because you're innocent, but because, for example, if they convicted you, but then the court said, yeah, but when you found that bloody knife in his car, that was an illegal search. So yes, his fingerprints were all over the knife. Yes, it had the victim's blood. Clearly the guy's guilty as all get out, but the evidence is gone. You have no other evidence beyond the bloody knife, so we're reversing the conviction. And it wasn't sufficiently clear in that statute that people like that would not be eligible. And so, and part of the reason was because they said, you'll take it to the ALJ, and the ALJ will just decide based upon the preponderance of the evidence that you are entitled to your compensation. Well, that meant that if the state didn't show up, if a particular prosecutor decided they'd just like to give out state money to people, and they didn't show up at that hearing, there'd be no one on the other side. Of course, the former ex-convict's going to say, of course I didn't do anything. I'm pure as new driven snow, and we would be paying out money on something that was clearly we should have been paying out on. So what they changed in this, a couple of key, but to me the key thing they changed was the ALJ, administrative law judge, has to find by clear and convincing evidence. So even if the Attorney General and the State's Attorney don't even show up at all to the hearing, the ALJ still has to review everything and say, yep, I've reviewed the packet and I find clear and convincing evidence that the state should pay you money. I think that's a sufficient burden. I think it's an appropriate burden, a burden of proof. I'm comfortable with that. They also, it was really convoluted last year, balancing back and forth between the state's attorney and the courts and all this stuff. And they cut all that out. So it's a simplified process. I can't speak to the financial, whether it's a good deal for the state financially or not. That's not my piece of this. But I think as a process for awarding these folks, it's a fair process and a reasonable process that will give the Walter Lomaxes of the world prompt relief, get them some money in their pocket, but it will also protect us, give us the assurance that paying these folks out, we're paying the right people out. It's real money, but they really deserve it. So that's just my 2 cents on it. Thank you.
Thank you, Mr. Chairman. I was a co-sponsor of last year's bill, but over time, kind of grudgingly came to the same conclusion that Senator Castley did, which is that we might accidentally compensate people who were wrongfully convicted but nonetheless guilty of the underlying crime, factually guilty. And you're right that it created a kind of Rube Goldberg machine. And I didn't share your concern about kind of state's attorneys and handing it out for election year politics, but I did share your underlying concerns about it. And I just wanted to agree from my side of the aisle that this bill simplifies that process and makes clear that it's only people who are factually innocent that can receive the compensation. So thanks to you for mentioning that. Thank you to the chairman and to the sponsor of the bill and to all the advocates who put this together for putting in just so much work to get this right. And I think we're finally there. I have nothing to add.
Yes, no, thank you, Mr. Chair. I want to express my own mea culpa. I was a co-sponsor of this bill last year, like Senator Wallstreicher. I supported it in committee. On the floor, I listened carefully to the floor debate, specifically the comments by Senator Castley. And so I voted at the end of the time not to support the truncating the process to have two bill sessions in one day, or two votes in second reader and third reader at the same time. I was called on the carpet by Delegate Dumais as being some sort of a turncoat, but I think that this year the bill is much better, and I think we need to commend Senator Castley for identifying a problem and sticking to his guns. And so I'm totally prepared to support this year's bill and to become a co-sponsor.
No, I'll just say this. Like, I also have to say I appreciate that, because I remember that fight on the floor, and I remember it in the committee. It was fun. No. Well, hey, look, I'll tell you this. Like, absent what anyone in the House did, in this committee, we sat, Vice Chair Wallstreicher, myself, Senator Kelly, a bunch of other folks, we sat down for like hours, based off of the conversation and the fight that we had on the floor and in the committee. And so, yeah, hats off to that. Thank you for. That's why this is a great process. That's why, I think it's important to listen to both sides of the aisle and everyone in the committee. So it was, taking that input, we worked with the advocates, worked with the senator, and made it happen. So I appreciate all the work that everyone did. And I would just say first, can we adopt the amendments that are before the committee? Is that everyone okay with that? Okay, great. Senator Jackson.
Sponsor, I've been riding the elevators with Senator Kelly, and we've been talking about this bill. And I think
You gotta watch her; she'll get you, man.
Looked at it, so
We had Senator Lee, Senator Carter, Senator Jackson, Senator West, Senator Sidnor, Senator Hedelman as co-sponsors.
Just read that list one more time so I get all of them.
Senator Sidnor, West, Hedelman, Castley, Lee, Carter, and Jackson. All right, is there further discussion on this, or? Second.
Vice Chair Wallstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Hedelman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. We should just end the day right there. That's all right. No, all right, so that we've got, let's do this. We've got one, I was going to, real quick, so Senator Sidnor, your bill 105 has a fiscal note on it that requires me to get prior approval from B&T. I've drafted a letter to ask for that, so we're going to hold that until I get that approval. Senator Hedelman, I put this on here to have this conversation, but this is going to be kind of a longer process also with B&T, so I'm going to hold that. but wanted to put that on there for discussion today. And then that leaves, we're not going to make any progress on Senate Bill 295 today.
Oh, yes, we could.
Or we could, I bet we could.
Yes, we could vote it.
And Senate Bill, I do want to talk about, we can come back to it if you want, but can we go to Senate Bill 20, Senator Carter?
I think that's easy. I thought there was a need for an amendment, but I learned there is not a need for an amendment, so the bill is fine as it is, as we heard it.
Okay, okay, great. Okay. I had an amendment that I wanted to run by you.
Oh, you could run if you have an amendment, fine.
Yeah, we'll see, so I do have and Josh, you can explain it, but basically, so there was a carve out for DUI, right? For the presenting your license if you've been convicted of what two convictions is it?
For the bill, and then I can explain the amendment. So the bill generally eliminates imprisonment as a possible penalty for a person convicted of displaying or causing to be displayed a canceled, revoked, or suspended license. The bill also reduces the points assessed from 12 to 3 for these violations. Exceptions are made when the underlying suspension or revocation is due to violations related to alcohol or drug-related offenses, refusal to submit to a test for intoxication, or an accumulation of points for certain alcohol or drug-related offenses. So the amendment that's been under discussion would basically get rid of that exception. So for the offense of displaying the canceled, revoked, or suspended license, which is a separate offense from driving with that license, no matter what the reason for the underlying cancellation, suspension, or revocation, the reduced penalties would apply.
I mean, it's a separate offense anyway. So for me, I mean, it makes sense. But if it's I don't want to hold it up for So if people have,
I could actually see how it could happen. I remember, so I've had a couple of clients who had their license suspended because they didn't go to the MVA when they had a DUI, but they had never turned in their license either because they didn't have it at the time when they were stopped or whatever. So the long and short of this is I've actually had clients who were not driving but still were in possession of their actual suspended license because it was suspended because they were stopped for a DUI and there was an automatic suspension because they didn't go to the MVA to request a hearing. So I actually know where people have been in possession of their license somewhat innocently, where it's their form of identification, but it's suspended. So they could be in trouble for displaying it. Like that's a scenario that's happened a couple of times I know about. So I get it, and it's fine with me if it's okay with the committee.
okay.
So it's a little bit, the amendment is not wordy, but it kind of, I can describe how I drafted it. It's currently in the amendment office in review, so I can't unfortunately guarantee that they won't flag an issue and change it, so I don't know if you want to move forward, but I can describe what it looks like at the moment, at least.
Is that enough for you, Senator Cassidy? Is that? Okay.
So on page 2, in line 11, it would strike the new Roman numeral 1, and then it would add, after subsection C, it would add D, comma, E, comma, and then it would strike all of the new language on lines 13 through 21.
Can we just get it and then run it
Yeah.
by the state guys just to make sure that we're not blowing this?
Oh, I had a question.
I'll defer to. Go, Senator.
I'm sure I remember the argument on this was that no one's actually incarcerated on this. The argument was that you needed this in order to get them to show up. I thought that was the whole reason we made suspended jailable. That was the argument forever on these. I remember that was Lou Simmons forever would kill these bills because he was like, no one gets rocked up, but you need to make it jailable or else no one shows up.
Right, I don't know. I don't recall that, but I know that the reason we're doing this is so that people won't be taken to jail and have to go to see the commissioner and go through that whole process because of this. So that's
I mean, I didn't think if you got caught with this, they actually take you to jail. I think they just like.
It doesn't matter if, like, the final outcome isn't the thing because nobody's going to jail for it. but they're going to get arrested for it, and they're going to have to be processed. They're going to have to see a commissioner because it's jailable. They have to go to jail if they get caught.
Look, I'm not going to arrest. I'm not going to take you. I'm not going to arrest you.
I didn't think people were actually even getting arrested on this. I thought there was an argument. I'm trying to remember back.
I've heard people getting arrested for suspended license.
I thought the argument was, though, that if you didn't have a jailable offense, it was harder to get them into court. They just no-show. So they get them on a suspended, then they no-show, and then there was, what does it change about making it jailable with the actual court process? Anything? Change like bench warrants or anything? I mean, does it have any practical effect on
So
that?
to be clear, driving on is still jailable. This is simply displaying, not driving. And I was explaining how could it possibly be that you are displaying a license that's suspended but not driving. And I was explaining that I've actually had clients who didn't know the administrative process with MVA but had a suspended license that they held on to because the officers never took it. Either they didn't have it on them when they were stopped or whatever reason. And they literally were walking around using their suspended license as their form of identification, but could have easily been arrested for that. So this would alleviate that concern. There's other scenarios too, but that's just one I know
You're saying they
about.
went to the bar, and then, okay, all right, and they showed the ID, and somebody could be like, that's suspended. But how would they know? They're only going to know you
it's
get pulled
more
over
like
in a car.
It's
You're
more
only
like
going to
an
know
authority,
that way.
it's like an authority figure.
I'll withdraw my amendment if you're just going to jam it up. If not,
I'd like to hear that if the committee has a problem with that. The clean bill is fine. This is good too. And I do think probably more people fall into this category where this would help them than the original bill. So I'd be happy to take your amendment.
all right, that means holding it for till next week.
Okay. Well, does anybody have a problem with the bill? All right. As long as we get something out of here soon.
All right, how long have we been in this room?
Too long.
My whole life. That's what it feels like.
All right, let's end this voting session now. All right, so that'll end the voting session for today, and then we'll go off. Floor leaders for.
Senate Bill 7, court therapy dogs.
Who wants to do court therapy dogs? Senator Jackson. All right.
Walter Lomax Act.
Oh, who? What a great message it would send. But this would be funny. If Senator Castley did the Walter Lomax Act.
I'm for it.
That would be great.
You said yeah.
Yeah.
You should just text her over.
Last year I filibustered
Yeah,
to death. This year I'm in favor of it.
I'll do that for now. We'll figure it out. 'Cause we'll see. We'll see. I'll let you know Monday. All right. What else? Do we pass out of here? Huh?
You're doing it.
Yeah.
And so then you've got Senator Hedelman, hate crimes, Hedelman.
So Hedelman, you're going to do your bills, basically all your bills. All right. What else have we passed?
That's it. We only passed 1, 2. We only passed 4.
Sweet.
Huh? Still good one.
Go ahead.
Yeah, oh yeah. And then don't forget the amendment issue because I'm also getting.
Okay, great. Yes, so it's 24 hours,
members
at least
that
24
can't
hours.
Find the amendments in advance, but I can't send them.
24 hours.
It needs to be 24 hours. Yeah.
All right, so just to remind everyone that amendments have to be in 24 hours in advance of our voting session. I think the voting gets, typically, we meet on Mondays, the voting list will get posted on Tuesday morning or something like that after we meet. So, should have enough time. So let's, just a reminder, 24 hours before. Yes, Senator Hedelman.
I don't know if this is appropriate, but I feel like I'm going to say it anyway. You can tell me if I'm out of line. But in the House, we tried to run amendments by sponsors of bills before springing them. So I don't know. I just think it's common courtesy. and I will do it. I promise to do it to others, and I would appreciate the same consideration.
So I've noticed. That's good. All right. No, I hear here. No, I hear you. Yeah. Just courtesy to everyone else, do your level best. Yeah, yeah. Yeah. Okay, so with that, that'll end the voting session, and then we've got a quick work session here. So we can go offline and we'll reboot. So,
What time, can you announce a time for the public, can you do it in like?
okay, great. Here we go. So look, I promised this work session we're going to keep it under an hour because this is the first bite at these bills. Jamie's got a brief kind of overview of what we're going to be discussing. We'll talk about it a little bit. Folks then can take what we've discussed a little bit, think about amendments, think about arguments, think about things you want to talk about at our next session. But I don't want to be here. I don't want to keep folks here for long. So if you could be back up online in 10 minutes, I promise you we'll get out of here. All right. Yes, it should be in your inbox.